Now, the push to have the EC chairperson answer 12 questions on how the 2020 elections were managed have been shut down by the Supreme Court. A key question now was tabled to be asked included whether or not the National Communications Authority assisted the EC in the transmission of the election results. The court, however, dismissed the request, holding that the questions are not relevant. Court correspondent Joseph Akablay is here in the studio with me. He will first tell us more about the questions that were asked to the EC, but, well, obviously not answered. Joseph, Joseph, we are welcome to the studio. So let's start with these questions.
Okay, so there are 12 of them. Essentially, they are questions that they want the EC chairperson to admit that she was the one who did the declaration of the results. And again, that in that particular declaration, there were some errors that were made. And they are asking her when exactly did she detect those errors and how did she correct those errors subsequently.
We can actually go through the questions one after the other.
So
yes.
there are 10 of them.
Yeah.
So let me quickly run you through the 12 questions. So the first question here says, was there a practice in previous presidential elections in the Fourth Republic of collated figures from constituencies being received in a strong room at the headquarters of the first respondent in the presence of agents of the candidates? The second question is...
Okay, so the first question, and you know it's very legalese, so let's try and break it down. So the first question is essentially seeking to find out what?
It's seeking to find out what the situation was prior to the 2020 elections, how the EC was...
So what is the convention?
From constituencies.
Right. So he's asking, what is the convention? So and the Electoral Commission was supposed to answer that question.
Yes.
Yeah.
The second was that practice described in paragraph 1 followed in respect of the December 7, 2020 elections? And so now, after you have answered in terms of what the procedure was in the past, you are being asked whether in the just ended election, whether you use that procedure or you use a different one. The third question is the 7th December 2020 presidential election the first time regional collation centers have been interposed between constituency collation centers and the headquarters of the first respondent? And so it's a direct yes or no question. The next one has to do with how were results transmitted from constituency collation centers to the regional collation center? The next one is how were results transmitted from the regional collation center to the headquarters of the first respondent, that's the Electoral Commission. Then question number 5 is question number 6 is, did the National Communication Authority facilitate in any way the transmission of results to the headquarters of the Electoral Commission? Then the 7th question is, when did Mrs. Jane Mensah, the chairperson of the Electoral Commission and a returning officer for the presidential election, first realized there were errors in figures she had announced in her declaration of 9 December 2020? Question number 8 is, how did Mrs. Jane Mensah, the chairperson of the Electoral Commission, get to realize there were errors in figures she had announced in the declaration? In respect of the purported corrections made to the figures in the declaration, was there any prior process of conferring with agents of the presidential candidates? And number 10 being that did the Electoral Commission chairperson, did she present to the agents to sign the presidential declaration form, and did all of them sign? Is another question that has been asked. And the final one has to do with, did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the results? And so
these are the 12
questions that they wanted the EC chairperson to ask. And they explained that this would have helped their case move faster, because if she had been allowed to answer the question, it will mean that they don't have to lead evidence to establish those facts.
These facts.
So
interesting.
If you answer the question that indeed there are computational errors, then there's no point.
Then we don't need to go back to that part of the conversation. But the EC was opposed.
Yes, the lawyer for the Electoral Commission, Justin Amenuvo, explains that a lot of the questions have been answered in the documents that the EC has filed. The only question that has not been answered, he says, is introducing facts that are not part of the petition. We can take a listen to Justin Amenuvo, the lead counsel for the Electoral Commission, as he argued against this request.
Yes, my lords. My lords, we are opposed to this application. Because we rely on all the depositions in our affidavit in opposition. Lords, with respect, the answers to the questions being sought are in the petitioner's own petition. The answer filed by the first respondent and also the answer filed by the second respondent. My lords,
well, that's Mr. Amenivo, right, yes. Speaking for the Electoral Commission. But was there also a response from the President's legal team?
Yes, Mr. Akoto-Ampao spoke briefly because the request was not, they were not the ones supposed to answer the question, but he said he had a point of law to make and the court allowed him to do that.
I'll have to sincerely apologize for that. We're having a little bit of a problem with the sound there. But Joseph, you can give us an idea what Mr. Akoto-Ampao said.
So what Mr. Akoto-Ampao said was that the rules allows that when you are making such a request, it should be on an issue that is in dispute. And so when it's not something that is in dispute, i.e. when the two sides don't disagree on the facts of it, there's no point in filing to ask them specific questions for them to ask. Once they've admitted to those facts, when they come into the witness box to testify, you have the opportunity to ask them further questions and not put them on paper and ask them to write and answer directly.
There was this point where, I mean, before we come to the court's ruling, there was this point where it looked like someone wanted to do, they were asked to, I think this was after the ruling, where someone was asked to file something.
Yes, so at the close of proceedings, what is left to be dealt with now has to do with the memorandum of issues, which has to do with the question that both sides agree that is germane to the case, the important matter that they must keep their mind on and they will need evidence to establish. So there's a question that you think that if this question is answered by the court, it resolves the election dispute. So they have to draft those questions and present it to the court. And the court will look at all 3 questions or maybe 6 of them, depending on how many each side drafts. And the court will narrow it down and select a certain number of them. So that is what they are supposed to do tomorrow. Now, Mr. Chikata was making the point that once the court had ruled that they could not file the application, he said they were a bit confused.
Okay, and it looks like I jumped you up a little bit. So let's come back to the court's ruling. The court's ruling was that it had dismissed it, but it gave reasons. Yes,
the reason the court gave was that Mr. Chikata was relying on CI 47, which govern high court rules. He said they are currently using CI 99 for the Supreme Court, and that particular rule is at the discretion of the court to decide whether to admit for such questions to be asked. But the court said that a case has not been made for the relevance of those questions.
Okay. Well, I'm not sure if we'll be able to bring that to our viewers right now. We will do that when we do Joy Prime News. But there were reactions after court today. Tell us about this.
So first, I spoke to Dr. Dominic Ayine. He's a member of Mr. Mahama's legal team, and he says that the decision of the court is very surprising in that they would have expected that the court would have stuck to his 2012-2013 petition decision, where the court allowed for such interlocutory processes to go through for further and better particulars to be supplied among others. Now he says this decision of the court leaves them confused. They do not know what should happen next, as in whether or not they are allowed to make any more applications in that regard.
Well, we can hear him.
They are based upon the existing rules. And if you listen carefully to what the learned, Chief Justice said, that given the new rules, that is CI 99, we could no longer bring an application for interrogatories in result of election petitions. That really is surprising to a lot of us as lawyers, because basically what the court has done is to overrule its own decision in the 2013 election petition without according reasons as required by the Constitution and existing practice and precedent. We think that the court sidestepped the basic issues that were brought before it. We think that the issues were very relevant because they went, they go to the meat, the integrity of the pleadings that were filed, that is the petition, as well as the respective answers. And in fact, if you were listening, counsel for the first respondent.
The position. So indeed, we were also opposed, much as the first respondent was also opposed. Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for a televised broadcast had already become moot, because the court had already set in place the procedures for a live telecast. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go insofar as this petition is concerned. There are ground rules which have been set for this petition, and the Supreme Court is not going to allow for unnecessary and interminable delays in the hearing of this petition.
So you had Dr. Dominic Ayene there, Joseph, and then we also had Frank Davis, who is representing the president, Nana Akufo-Addo side. What happens next?
So tomorrow morning, they are supposed to file the memorandum of issues by 9:30 a.m. Then once the court comes in, they'll present it to the court, and the court will decide which one to adopt. And so that's the business for the day tomorrow.
All right, so tomorrow you want to keep your dials right here. Certainly don't take them off from now.